today to talk a little bit about evictions and like the new national, state, and local protections that are currently in place during the COVID-19 pandemic. My name is Marya, Iyyani. I'm a housing fellow here in our Contra Costa office, and I'll be presenting today with my colleague Sophia, who also is a housing attorney in our Contra Costa office. So before we get started, we just wanted to do a few poll questions to get an idea about who we're presenting to today and what areas of Contra Costa you might be serving. So Sophia, would you go on to the next slide? And Chelsea, could you run our first poll? So we just want to know, what part of Contra Costa County do you represent? West, Central, East, everywhere?
Can you see it, or only I can see it?
We can't see the responses, but we can see the poll itself has popped up.
Okay,
Sophia
great.
and I, at least.
Okay. Well, let's see. We have just a few more folks voting, but it looks like so far almost half folks are all of Contra Costa County, and then about 15% just West County, 30% just East County, and 10% in Central.
Great. So we have a pretty good mix, it seems like, and that's good to know. We'll spend a lot of time talking about the state protections and the county protections, and less time talking about city by city, but we have all that information in this PowerPoint for your review for later. So Sophia, would you go to our next slide and our last poll question? And Chelsea, if you could run our second, you keep going forward. And Chelsea, if you could run our second poll whenever we get there. So do you work with individuals or families who are facing eviction for any of the following reasons? You can tick off however many you're seeing.
Wow. This is my first time using polls, and it's incredible. I hope all of you get to be on this end and see the results roll in. Okay, with about half of the folks who have responded so far, it looks like the top options here are unable to pay rent and unable to pay rent due to COVID-19.
Wow.
And then discrimination around 35%, so that's the next largest category. And all others are around between 15 and 25%. But
yeah,
it looks like those first two, unable to pay and unable to pay due to COVID, are definitely by far the highest responses right now.
Well, that's really good to know. So that's what we're going to spend the bulk of our presentation talking about, the specific protections that are in place for tenants who can't pay rent due to the COVID-19 pandemic. And so we'll start jumping into that now. Sophia, do you want to go to the next slide?
All right. Well, thank you everyone for being here. It is really so great to see so many people here today. You're all here because you understand what's at stake for families when facing eviction or any kind of housing stability. As you'll see in this slide, more than one in 3 Contra Costa County residents are renters, including the majority of Black, Latinx, and immigrant residents. And as of July 10th, 2020, 12,000 Contra Costa County households, including over 10,000 children, are at imminent risk of eviction and homelessness. Most people will be affected by the eviction crisis in some way, but data tells us that some communities will face a disproportionate impact. Due to COVID-19 pandemic and racial, economic, and other disparities that existed before the pandemic, the eviction crisis will hit Black, Latinx, and immigrant residents the hardest. This will only serve to further widen the health and economic disparities between these groups and their white counterparts. Unfortunately, legal service providers such as Bay Area Legal Aid will not be able to assist everyone who is facing an eviction. And this is where you all come in. Through this presentation, we are hoping to provide you with the cursory knowledge of the laws protecting tenants so that you are equipped to help any client, neighbor, or community member who fears losing their home. Okay, so we'll start off by providing a brief overview of the unlawful detainer process. Unlawful detainer is the legal term for an eviction lawsuit. and we call it UD for short. So throughout this presentation, when we say UD or unlawful detainer, we'll be referring to an eviction case that a landlord has filed in housing court. Here's a flow chart of the unlawful detainer process. So this flow chart shows the different steps from receiving an eviction notice to an eviction lockout. And you'll see that there are many steps in between for a tenant to assert their rights and settle the case. Today, we're going to be focusing on the notice stage at the very top, which is right before a court case is filed. When we talk later about new notice requirements in the new tenant protection laws, you can think back to this chart and this process of an eviction. Now, I want to note that the notice is only the first step in the unlawful detainer process, and tenants do not need to move out after the notice period. You'll see there's many opportunities for a tenant to continue to fight their case. The chart also shows how important it is for a tenant to file an answer. You'll see on the right side, there are many more steps and way more time for tenants who respond to the court case rather than not filing an answer at all.
So because we're going to spend so much time talking about notices, we want to provide a brief overview about different types of notices, common notices that you may have seen in your work now. So the two big umbrella categories are for-cause notices, which are those that list certain reasons, and then no-cause notices. And a no-cause notice is not going to list any reason for eviction. It might just say, oh, you have to leave in 60 days. Or the other example we have here is your lease expires and there's no reason I'm evicting you. It's simply that your lease is expired and so I'm giving you 60 days to move. The portion that we're going to spend a lot of time on today is for cause notices, because these are the notices that are allowed underneath the state and national protections that we'll talk about. And underneath for cause notices, so we're going to use a couple of different phrases over the course of this presentation. Just cause is the legal term we use to describe permitted reasons for eviction. We also say for cause, okay? Underneath for cause notices, there are different types. The most common that we'll probably talk about today is pay rent or quit. Perform covenant or quit, which refers to lease violations. Some notices are just a notice with no opportunity to fix the problem, so that might be criminal activity, something like that. And then the final common type of a for cause notice would be one that is for no fault. So if you don't pay your rent, if you violate your lease, we're going to say that the tenant is at fault, and this is a at fault notice. No fault means the tenant hasn't done anything wrong, but there's something else going on with the property that would require the tenant to move out. So we have some examples here. If the owner wants to move in, if the owner wants to stop renting the property and take it off the market, if the unit is unsafe and there needs to be like substantial remodeling, anything like that. And we're going to go into this in a little bit more detail later, but I just want you to have this in your mind that there are these two big umbrellas. There are for cause notices and no cause notices. Next slide, Sophia. And the reason this is so important is because when a notice is not technically correct, when it's invalid, when it's not properly formulated, the landlord has to start all over. An eviction case cannot be based on a defective notice. So for example, in general, if you don't pay your rent, your landlord needs to give you 3 days to pay your rent or quit. So they'll give you a notice for 3 days. If they give you 2 days, for example, that notice is defective and the landlord would have to start all over because the eviction case can't be based on that. So we really want to look at all the notices we're getting over the next few months so we can weed out any technical defects and make sure the landlord is doing everything correctly and preserving tenants' rights, okay? Next slide. And the other really important facet of unlawful detainers that I want you all to remember is that After the notice comes the summons and complaint. The summons and complaint is a big packet from the court. This is what the cover will look like, and this is the actual lawsuit. This can only be filed in the court after the notice expires. I bring this up because I want you all to remember that if a tenant gets a summons and complaint from their landlord, it is really, really important that they file their response within 5 court days. This excludes the weekends and judicial.
Oops, Maya froze for me. Is it working for you all?
She's frozen for me too, sadly. Other folks in the chat are saying frozen, frozen.
Yikes. Okay, well, I will pick up where Maya left off, which is you need to file the answer after 4 court days, and it does not include weekends or any judicial holidays. After the 5 court days, if the tenant doesn't respond, then the landlord can go to court and automatically win and seek an eviction notice and lockout. Now, if it's been 5 court days and the tenant hasn't responded, we still really want to encourage you all to tell tenants to file the answer anyway, because at that point, it's kind of like a race to the courthouse. If the tenant can file the answer on the 6th or 7th court day before the landlord tries to seek a default judgment, then they still have the opportunity and they're still preserving their right to fight the case in court. There it is. You can still technically file afterwards, and you should. All right, so what about now? There are different protections, and we're going to go over different eviction protections for tenants on the federal, state, county, and city levels. All right, so the national protections are going to cover, and you might have heard these, a lot of buzz around these before, the Center for Disease Control, CDC moratorium, and the Coronavirus Aid, Relief, and Economic Security Act, also known as CARES Act. So the CARES Act, the big thing about the CARES Act that we want you all to know is that it requires 30-day notice for any reason to vacate. And so, like Maya mentioned, normally a landlord, if you're behind on rent, a landlord will provide a 3-day notice. In this, if the unit is covered by the CARES Act, then it has to be 30 days. And dwellings that are covered under the CARES Act include properties that participate in a federal subsidy program or tax credit program or have a federally backed mortgage. So some of the most common examples are Section 8 housing choice vouchers, project-based housing, etc. Okay, and the CDC order. So the CDC order went into effect on September 2nd, and it goes through the end of this year. And under the CDC order, tenants cannot be evicted for failure to pay rent if the failure to pay was because of income loss or medical expenses. What's notable here is that the failure to pay does not have to be related to COVID-19. So it actually has a fairly broad reach. And it can be applied to rent accrued before March 1st. So if a tenant is behind on rent prior to the pandemic, prior to the shelter in place, the CDC order is still intended to protect those tenants. And the reason is, of course, to prevent homelessness and the spread of COVID-19 during the pandemic. Now, after the moratorium, tenants can still be evicted for any unpaid rent balance. Tenants still owe the rent. It's not forgiving any rent. And tenants must pay as much rent as they can each month. And so to get protection under the CDC order, tenants must give a declaration of hardship under penalty of perjury, and they can serve this to the landlord at any time. This is also a unique piece of this protection because, as you'll see later, the state protections require tenants to submit a hardship declaration within a specific period of time. But the CDC order, the declaration for the CDC order can be submitted at any time. And advocates also interpret this order to prohibit all no-fault evictions. In addition, in order to be protected by the CDC order, the tenant must make under $99,000 per year, and it does not preempt any state or local protections that are more productive. And it looks like Maya is back.
I am. I'm here. I'm going to keep my camera off so I can utilize as little internet as possible, but I'm here and hopefully we can get through this.
Great. All right, statewide protections.
Yeah, so mainly we're going to be talking about the COVID-19 Tenant Relief Act of 2020. I'm sure you all have heard a lot right now. I'm sure the number 25% has been floating around. So we want to jump into the details of this act and what it means for our tenants. And one thing we really want to emphasize is that the courts are open now and a lot of cases are being heard. So Sophia, will you go to the next slide? So the Tenant Relief Act is also known as AB 3088. So we'll refer to it both ways throughout this presentation, but this is the state law protection, okay? So the basics, this applies to all tenants across the state, and non-payment evictions actually began under this law on October 5th, so this week. We're going to hone in on these non-payment evictions because there are ways to prevent non-payment evictions. So tenants are never evicted, or we can delay the evictions. But if your loss of income, for example, is not related to COVID-19, those evictions can begin starting this week. The other big protection under the state law is that landlords have to have a permitted reason. So they have to have just cause, or as we mentioned earlier, to evict any tenant until February 2021. Previously, landlords could issue those no cause notices we talked about earlier, right? So lease expiration or just not giving you a reason. But under this law, every tenant has the right to a reason, a permitted reason for being evicted. And this applies to mobile homes too. And there are certain permitted reasons under this law that that landlords can use to evict tenants, and we're going to go into that in the next slide, Sophia. So I don't want to go into too much detail with this, but as you'll see, our just cause reasons, our permitted reasons, are split into two categories: those in which the tenant is at fault, and then those in which no one's really at fault. There's a third reason for which the unit is no longer going to be, or the tenant's no longer going to be able to remain in the unit. Our most common, so our at fault reasons, this is an exhaustive list. Non-payment of rent is the most common thing that we all see, as was shown in our poll earlier. Other lease violations, nuisance, criminal activity, illegal subletting, not letting the landlord into the unit, failing to leave the unit after agreeing to do so, and also refusing to sign a lease under similar provisions. So if tenant does any of those things, landlord can bring a notice and pursue an eviction against them. Other reasons that landlord can evict, even if tenant doesn't do any of those things: if they have to demolish or substantially remodel the unit, if they're withdrawing the unit from the market, if they or their relative is moving in, or if they have to do so because of some type of government order. Next slide. And like I mentioned earlier, what is not just cause for eviction? If there isn't any reason listed, and if, for example, the lease is ending, that is not enough for the landlord to evict right now. The landlord is going to need to use one of those permitted reasons in order to evict a tenant during this time. Next slide.
Okay, so we're going to spend some time now going over the protection specifically to non-payment of rent cases. And so the Tenant Relief Act provides new notice requirements, which extend the notice period, and we're going to go into more detail on that on the next slide. It also created a hardship declaration, and it created two key time periods for non-payment protections. The first is from March 1st through August 31st, 2020, and then September 1st through January 31st, 2021. So let's talk about the notice requirements. Any notice to pay rent or quit must provide 15 court days instead of the usual 3 days notice, and it must include a copy of the declaration of COVID-related financial distress for the tenant to sign and return, and it must include information regarding tenants' rights under the Tenant Relief Act. And remember, these are very strict requirements. If a notice is missing any piece of this, then it's defective, the notice is illegal, and the landlord will have to start over. That's why it's very important to be able to identify all the requirements in the notice, and the landlord has to follow every single requirement. And as a note on the declaration, no proof is required from the tenant. The tenant only needs to submit the declaration, just that single piece of paper itself, unless the landlord shows the tenant has an income over 130% of the area median income, which is fairly high, and generally most of our clients are under that. So the declaration of financial distress basically declares that the tenant has lost income or had increased expenses related to the COVID-19 pandemic. Examples include because of increased childcare duties, increased costs for medical expenses, but really it's very expansive, and any circumstance that's related to the pandemic or just to the shelter in place and the close of businesses is a reason and would be considered pandemic related. Here is a copy of what the declaration looks like. It's available in different languages on the state's website, and when the landlord attaches this to their notice, it has to be provided in the language that the lease is negotiated in. And I also want to remind you all to tell tenants to take a picture of this declaration before they send it into their landlord so that they can have proof that they did submit this, because a lot of the protections depend on the tenant submitting this declaration to their landlord.
So under the state law, there are two big time periods that require tenants to do slightly different things, okay? So there's first the rent that accrued between March 1st and August 31st. So the rent for this period can never be the basis of an eviction action as long as the tenant submits one declaration of COVID-related hardship within the 15-day notice period. And so this notice just covers all of the rent from March to August. And then as long as they submit that declaration, they don't have to pay anything in order to not be evicted. Any unpaid rent, as I said, cannot be the basis of an eviction, but it's really important to remember that technically the tenant still legally owes this money to the landlord. And so rather than being able to evict the tenant for the rent, the landlord can go ahead and collect on the rental debt, for example, through small claims or a civil action. Next slide. Now, the rent moving forward is what's really relevant at this time. So this is rent from September to January. Now, not only must the tenant submit a declaration of hardship, they have to do so for every single notice that they receive during this time period. And the landlord can give a notice every single month. So when September rent's not paid, the landlord can give a notice. Tenant would need to submit a dec. If October rent's not paid, landlord could give a notice, and then tenant would have to submit the declaration again, okay? In addition to submitting a declaration for every single notice served, the tenant also has to pay 25% of the rent owed between September and January. And this can be paid in installments as long as the entire thing is paid by January 31st. So they could just pay all of that rent on January 30th or January 31st, and they would be entitled to the protections of this state protection as long as they also submitted the declaration. One thing I would note is that it's really important for tenants to clearly mark what their payments are for during this time period. For example, if tenant pays 25% of their October rent, they want to write this is 25% of October rent on the check, money order, whatever it is. Because what we don't want to happen is we don't want landlord to come back and say, well, I'm applying this money you gave me to the March rent that you never paid, because that would then preclude the tenant from having this protection. Okay. And like I mentioned earlier, as long as they pay all of this money and this 25% and also submit their declaration, they can never be evicted for those months. However, they do still owe the remaining 75% of rent, and the landlord can try to collect via small claims or civil court, as mentioned. But even if the tenant pays nothing from September to January, because they have until January 31st, as long as they return their declaration, the actual eviction can't be filed until February 1st, because it's not actually considered late until January 31st. Next slide. So like we said earlier, it's really, really important that the tenant submits their declaration within the 15-day deadline. However, if they don't submit within the 15 days, there is one alternative option in which the tenant can still submit the declaration within the time to file their answer. So you might remember from earlier, once they're served with the lawsuit, the tenant has 5 days to respond with their answer. If they haven't submitted their declaration, they can also submit their declaration within those 5 days to submit their answer. However, it will not automatically be accepted the way it would if it was submitted during the 15 days. Instead, the court is going to hold a hearing and basically ask, did you have a really good reason for not submitting during the 15 days? So they'll ask whether there was some type of mistake, or if you had something called excusable neglect. So one very, I think, straightforward example of excusable neglect might be, I was in the hospital when my landlord served me with this 15-day notice, and so I literally could not respond, right? Or they served it to me in English and I don't read English. That might be another example. But regardless, even though we know we have these extra measures in place to protect the tenant, we really want to recommend that they submit it within the 15 days to avoid the need for a third party to determine whether their reason was good enough, right? Next slide. So I'm just gonna keep repeating this. Even though these protections are in place, so that tenants can't be evicted, they still technically owe this money, okay? So landlords can start collecting the COVID rental debt. They can start collecting the rental debt in small claims court beginning March 1st, and they can collect using other methods like filing a civil collection action or reporting the debt at any time. However, it is also important to note that landlords must offset any financial assistance they've received. They can't just receive the financial assistance and still offset the cost to the tenant. And one more protection that's good to note is that generally when eviction is entered against a tenant within 60 days of filing of the complaint, that record is going to be public. However, right now, all non-payment evictions that have been filed between March and January are going to be masked whether or not the tenant wins or loses. Next slide.
All right, next we'll go over some local protections with the focus on Contra Costa County. So generally speaking, your county or your city might have different protections, and there's been a lot of questions about how the local protections interact with the state protections or the federal protections. The short answer is that the older ordinances remain in effect until they expire, and after a county or city's ordinance expires, then the state law would apply. Local governments under the state law can always pass more protective just cause measures. And we'll see that Contra Costa County did this, and we'll go over their emergency ordinance next. For ordinances that give tenants a specified period of time to pay rent, the repayment must begin by March 1st, 2021 and completed a year later by March 31st, 2022, unless the local ordinance calls for an earlier repayment schedule. And this mostly applies to city ordinances that provide different repayment schedules and repayment grace periods. So Contra Costa County Emergency Ordinance number 2020-25. This was passed very recently after the State Tenant Relief Act was passed, and it provides additional protections, just cause protections. And so it's in effect through January 31st, 2021, and until then, tenants cannot be evicted for having an immediate family member living with them for COVID-related reasons. So if a tenant's immediate family member would otherwise be an unauthorized occupant, but they're living with the tenant because of the pandemic, they cannot be evicted for that reason. And tenants cannot be evicted for substantial renovation. So if you'll recall, substantial renovation is one of the no fault just cause reasons that's permissible for landlords to evict. But Contra Costa extended the protection and prohibits landlords from evicting tenants for a substantial renovation. Lastly, rent increases. This has also been, I've gotten a lot of questions about this, especially as the pandemic has continued on. So while the Tenant Relief Act doesn't provide any specific protections or prohibitions against rent increases, a landlord cannot increase rent under the state price gouging rules. The price gouging protections came into effect when the governor declared a state of emergency. So that began on March 4th, 2020, and the COVID-19 statewide emergency extends through March 4th, 2021. And through this time period, the governor has also declared a state of emergency for wildfires and extreme heat. And the same rules apply. During the state of emergency, the landlord cannot increase rent for more than 10% as long as the state of emergency is in effect. The one exception to this is that it doesn't apply to rent increases that the tenant and the landlord agreed to prior to March 4th, 2020. So if the tenant and the landlord had previously had a written agreement that rent was going to increase after, let's say, on January 1st, then that would still apply. Now, Contra Costa County has also extended their protections with respect to rent increases, and the county prohibits rent increases through January 31st, 2021 for properties that would normally be covered by the statewide rent control. So this means that the rent can't be increased at all, not even $1, for properties that are covered by rent control. But again, it doesn't apply to any pre-scheduled or agreed upon rent increases.
So there are several cities within Contra Costa that have their own protections, their own repayment protections. We're not going to go through them in detail. We will send out these slides afterwards so you can look through them for your particular jurisdictions. The one thing we just really want you to remember is that regardless of the repayment timelines that are in place in local jurisdictions, in order to be protected by the state law eviction protection, in order to ensure that you can never be evicted for rent between March and January, it's really important that tenants follow the state requirements, right? So that means submitting their declaration, and for the rent between September and January, that they also pay the 25%. So when we send this out, please take your time looking through it. And if you do have any questions, we're going to provide our emails at the end so we can help people on a case-by-case basis.
So here's a sneak preview of Marya, Concord, El Cerrito, Pittsburgh, Richmond, San Pablo.
Perfect. So what we want to do now is go through some hypothetical scenarios and test what we've gone over the past 40 minutes. So what I'm thinking is best is we'll just go ahead and read the question out loud to y'all. And if you just want to throw your answers in the chat, we can have a little bit of a group discussion. You feel free to send it to the panelists or to the panelists and attendees, whichever you are most comfortable with. Sophia, next slide. So Tom Tenant has rented a single family home from Larry Landlord in Concord since 2015. Tom has always paid his rent on time. In March, however, due to the COVID-19 pandemic, Tom lost his job and could no longer afford to pay his rent. He hasn't paid rent since then. On October 15th, 2020, Larry serves Tom with a 3-day notice to pay rent or quit. Is this legal? Yes or no? Give you all a few more seconds. Okay, yeah, I'm seeing some great answers and some expansions. So, Sophia, do you want to go to the next slide? So yeah, most of you are right. It's no, the landlord cannot do this because under the state law, under Tenant Relief Act, AB 3088, Larry must provide 15 days notice to pay rent or quit to Tom. He cannot simply provide 3 days. And he also has to attach that declaration of hardship so Tom can attest that he's lost his job and can't pay rent due to the COVID-19 pandemic. And, this note actually is not quite accurate anymore, but we're looking to AB 3088 because we're looking to the eviction protections, right? And so we want to make sure this 15 days is in place and that the notice is perfectly technically correct before Larry can move forward. Next slide.
All right, now it's October 10th. Larry serves Tom with a 15-day notice to pay rent. Tom is unable, however, to pay any of his back rent. Can Larry still attempt to evict Tom? And what can Tom do to protect his family from an eviction? We'll give you another minute to ponder this, and feel free to put your answer in the chat. And you can send it directly to me or Maya as well. Yes, it looks like some of you know exactly what the answer is. Well, actually, it's a yes. It's kind of a yes and a no, the answer. So Larry can attempt to evict Tom if Tom does not provide a signed hardship declaration stating that he had decreased income or increased expenses related to COVID. However, if Tom submits a written declaration within the 15-day notice period, he's protected from eviction. Without the declaration, however, Larry landlord can argue that this is just a regular non-payment and therefore a basis for filing an eviction case. And Tom should always keep a copy or a photo of the declaration of proof that he submitted it.
Right, and like we mentioned earlier, these non-payment evictions started this week, October 5th. So it's really important we keep an eye out for these non-payment of rent notices so we can ensure tenants submit those declarations and prevent the eviction. Next question. So Tom submits the necessary declarations of hardship, and so Larry cannot evict him for non-payment of rent until February 1st. Instead, on November 1st, 2020, Larry serves Tom with a 60-day notice to terminate tenancy with no cause listed. Can Larry evict Tom for no cause? All right, answer is just shooting into the chat immediately, so that's great.
It's unanimous consent.
Yes. So the answer is no. AB 3088, as we mentioned, extends just cause, that for cause permitted reason protections to all tenants through January 31st. However, this protection does expire on February 1st. And so Larry can file an eviction action based on a no cause starting then. Normally, Tom isn't protected by the state just cause requirements because he lives in a single family home owned by Larry, and that's why after February, he won't be protected. Next slide.
One more question. Okay, we've fast forwarded and survived the election, and it's now January 31st, 2021. Tom has not paid any of his rent, but he has submitted his declarations of hardship. What must he do to avoid being evicted for non-payment of rent? Yep, y'all got it. Tom must pay 25% of all the rent he owes between September 1st and January 31st in order to avoid eviction for this non-payment. And as a reminder again, Tom must submit his declarations of hardship in order to acquire these protections. And as another reminder, when Tom is paying the 25%, be sure to designate which month the rent is for, so that the landlord cannot apply it to, for example, March or April rent. And I also saw a question in the chat from Betty. If we pay a landlord rental assistance for a client, can we designate that it be used towards the 25%? And the answer is yes. The same way we advise tenants to designate what the payment is for, organizations who are providing rental assistance should do the same thing. And just to make it extremely clear. And again, just like with the declarations, we recommend that the tenant or the organization keep a copy of that payment and the designation so that they have proof of what was on the payment and how much was paid. Okay, so that was all the hypotheticals, but I know that there are some questions in the Q&A, and please feel free to put in more questions. We left a lot of time for questions because we want to make sure we all understand the protections for tenants, even though there's so many different rules and laws going on. Please don't hesitate to reach out to me or Maya, since many issues do have strict deadlines. So our emails are here below. Feel free to email us. We're also providing the legal advice line number, which is the number that tenants can call to seek legal assistance. And if they call that legal advice line, they'll be able to speak directly to an attorney. Shall we go through the Q&A now?
Yes, that's great.
Okay. So Sarah asks, does a criminal activity have to take place on the property? And I'm going to just go back in the slides to that fun chart of the just cause protections. Maya, do you want to take this one?
I would argue that yes, it has to take place on the property to be evictable. Sophia, I don't know if you have a different position than me. I think
that's definitely what I would argue.
This is, there's, the law, this is an annoying lawyer answer, but the law is very gray. And I could imagine a world in which a landlord tries to bring a case in which someone commits some type of criminal activity way off the property that has no impact on their tenancy, and the landlord tries to evict them for that. We would argue this is completely irrelevant to their tenancy. And so no, you cannot move forward with this eviction. So I would say yes, it needs to take place on the property. Someone else asked, does the declaration have a due date to when the notice was received? So yes, right? So it's 15 court days from when the notice was received. That 15 days is really, really important. The same person asked, can the tenant provide all the declarations at one time? This is a really great question, and we've been getting it a lot. And, our position is the safest thing a tenant can do is submit a declaration for each month as soon as they know they can't pay their rent. Yes, they don't have to submit the declaration until the landlord serves the notice. However, we may not want to wait for landlord to serve a notice in January for all of the rent, especially because what if the landlord doesn't provide the declaration? We just want to
put tenants first and have us secure our rights ahead of time. One thing I'll note is, so the person asked, should they submit all their declarations at once? They may not be able to submit all their declarations at once, because under penalty of perjury, you may not be able to say, I can't pay November rent, because I don't know what could change between October and November. So you shouldn't submit the declaration until you can say, I cannot pay this month's rent because I do not have income right now, right?
Yeah, and this question also reminds me that every tenant should sign a declaration just to ensure that the entire household is protected from eviction. And so that can be each tenant signing their own declaration, or they can sign the same declaration, but just to ensure that every person in the household is protected, they should all sign the declaration. Erica asks, where can we get the declaration forms? So in an ideal world, the tenant would receive the declaration form when the landlord serves them with a notice to pay. But, you know, we can't always trust landlords to follow the law. So if you need to obtain the declaration, you can find it on the state's website, and a lot of city and the county websites also link to it. It's standard language, really simple. You don't have to provide a lot of information really at all. So if you're still unable to find it, you can email me or Maya, we can send you a copy as well. And like I said before, the declaration is available in different languages on the state's website.
The next question is, if a tenant vacates a property without notice and does not pay rent, can the landlord claim any unpaid rent from the security deposit owed to the tenant? So in general, landlords can take unpaid rent from the security deposit. This is more of a contract question than anything. For example, if you left your lease early, you're technically on the hook for the rest of the lease. Because you signed a contract saying you would be there for that time. The landlord does have a duty to do something called mitigate damages, which means the landlord would have a duty to try to find a new tenant as soon as possible, so they can have someone else paying that money and not necessarily put it on the previous tenant. So it is always in the tenant's best interest, not always, but it is generally the tenant should submit notice so that they're not on the hook for any longer than the landlord expected them to be there. Sophia, I don't know if you have any other thoughts on that question.
Yeah, I think that's right.
Okay.
Yeah, if the tenant knows that they're gonna move out, they should definitely let the landlord know as soon as they can. Victor asks, can a tenant who sublets a garage to a tenant evict that particular tenant for a permitted reason? So this is a question about kind of subletting, and it also reminds me of a question we got before about whether a tenant who is just renting a room in the landlord's house, whether they are protected. And under AB 3088, the state's Tenant Relief Act, they are covered by just cause protections. And so they, the master tenant or the landlord must have a permitted reason in order to evict them before January 31st, 2021. Maya, is that right?
Yeah, and one thing I would note also is, like, in order to bring an eviction lawsuit, you need to be like the owner of the property or have authorization from the owner to bring that case. So if it is a tenant who is trying to initiate the UD, that it gets a little bit stickier and they may not be able to do that. Right?
Mm-hmm.
Let's see. So the next question is, if a tenant has an approved roommate and is paying their portion of the rent, but their roommate is unable to due to COVID, are both roommates in jeopardy of eviction? I think this is going to depend on whether they have separate leases or not. If they're on the same lease, then technically everyone is responsible for the entire rent. And so if any of that rent is unpaid, even if the roommates have a private agreement to split it, everyone will be at risk of eviction. However, if they have separate leases for individual rooms, for example, then one roommate's failure to fulfill their lease obligations shouldn't impact the other roommate.
Yeah, and if the tenants are all on the same lease and one of the roommates is unable to pay their rent because of COVID, they should still submit the declaration of hardship and still seek the protections, because they're,
right,
even though they might not be family members, their household, for the purposes of lease agreement, has decreased income or increased expenses related to COVID. And so that is a protection that they should seek, and they are entitled to under the Tenant Relief Act.
Yeah, that's a great point, Sophia.
And one other thing I wanted to mention, actually wanted to mention it about an hour ago after that initial polling question. I wanted to touch on discrimination. So as you'll see, discrimination is not a reason ever to evict anyone. However, as we know, landlords discriminate all the time. And there are fair housing protections to protect tenants who think they are being evicted because of discrimination. And I would encourage anyone who is worried about that to contact Bay Legal or reach out to me or Maya. And for tenants who have disabilities, they are also entitled to seek a reasonable accommodation for their disabilities. And under the fair housing law, the landlord is required to provide that accommodation. And so these are things that we can also assist with. So I didn't see any more questions, but does anyone else have any questions or thoughts that they would like us to address? Oh, here is a question.
And Sophia, would you bring the slides back to our contact information so folks can write down our emails in case they do have questions later? Thank you.
Here we go.
Sophia, I see one other question that's actually in the chat. Do you see that?
Yes, it says, when you say rent increase agreement, does the tenant must agree to the increase, or does the landlord need to send a notice and that's it? I would argue that the tenant must agree to the agreement. And so one way I'm envisioning this would play out is like if the lease says that after 1 year, the rent will go up by like $50 or something, hypothetically, then that, and the tenant and the landlord both sign that agreement, that would be something that I would consider to be pre-scheduled. But if the landlord just sends a notice unilaterally, I would argue that that's not sufficient. Maya, what do you think?
I think that's right. I agree with you.
Yeah, and I know landlords can also try a bunch of different things to get more money from their tenants, and the state's protections also prohibit landlords from saying that they're increasing their services, like utilities, for example, as an excuse to increase the rent, the monthly rent payments from their tenants.
And I see one more question in the Q&A. If we have clients who could use your services, do they call the legal advice line or can they email you directly? So all potential clients need to go through our legal advice line because they need to be screened for eligibility before we can assist them. And so, if you have any clients in mind, please give them the legal advice line number. If you have any questions about or sending someone over or about the law itself, you should feel free to email us, but any tenants should definitely call the legal advice line.
Thank you so much. I see another question come in, but I just want to mention before folks start hopping off, because we're right at 12 o'clock, that we recorded this, which we can share, that the slide deck will be emailed to everyone. hopefully this afternoon, and that we will include a very brief evaluation, which really helps Family Justice Center and helps our presenters when we think about future trainings. We love feedback. So as an exchange for the slide deck, fill out that little evaluation for us. And we're not going to get cut off this time, so I want to make sure, Sophia and Maya, if you've got a minute to answer these questions, but I see some folks are needing to hop off right on time. So
Thank you, Chelsea. Yes, there's 2 more questions. Are we both working out of the Richmond office? Yes, Maya and I are both based in Richmond, but Bay Legal's Richmond office serves all Contra Costa County residents. And unfortunately, because of the pandemic, our offices are closed to the public right now, and we don't have a date in which they'll be open. So please don't send clients directly to our offices. If necessary, for whatever reason, under the circumstances, we are able to meet with clients directly, but are just kind of on a case-by-case basis. And one last question I see. What if you have a tenant who stopped paying rent in February, but still had disability income, but chose not to pay for their Section 8 housing? Can the landlord evict?
So in order to submit a declaration under basically any of these protections, the tenant has to attest that they cannot pay their rent due to like a loss of income or medical expenses or something like that. If the tenant can in fact pay their income, they won't be able to submit that declaration and therefore would not be able to procure the protections. Do you agree with that, Sophia?
Yeah, and I would also say if the tenant has the money and is able to pay their rent, I would encourage you all to assist the tenants with negotiating a repayment agreement with their landlord. Mm-hmm. And oftentimes the landlord will be happy to agree to do that in lieu of filing an eviction case. So yeah, I would fight back.
Right.
If you need assistance, you can contact us. But yeah, if the tenant does have the money, I would encourage them to try and pay as much as you can, either now or later.
All right, well, thank you so much, everyone. We'll be here for maybe a few more minutes if there are any last minute questions. Otherwise, if you do come up with any questions over the next few weeks, definitely feel free to email us.
Thank you, Sophia. Thank you, Maya. I hope you are looking at the chat and seeing all of the great info. Thank you so much. Thank you so much. So useful. A lot of love and praise in the chat.
Thank you, everyone. We're so happy that so many people were able to attend today. One more question. Is it possible to send packets to Richmond Court?
Yeah.
Yes, we do want to do that.
Yes, I just spoke with someone on the phone last week at the Richmond Court, and I plan to drop them off soon. We're just finalizing some edits, and I'll drop them off to the courthouse, hopefully this next week.
Yeah, we've been trying to keep up with all the changes in the law, and so has the Judicial Council, and so the answer forms for eviction actually just changed this week, and so we are just in the process of updating our packets, and once they're finalized, we will distribute them and encourage you all to distribute them.
I see a few more questions. Someone asked, is a rental contract needed in order to evict or a verbal agreement binding in court? Yeah, so no, you don't need a rental contract. A tenancy can be formed in multiple ways, and one way is through a rental contract. Another way a tenancy can be formed is verbally, and also just through behavior, right? So if I live somewhere for a year and I pay my landlord rent every month and he accepts it every month, we're going to have a tenancy whether we actually have a contract or not.
And Chrissy asks, would you suggest for renters initiate a payment agreement with landlords even if they're protected? A number of clients have advised their landlords will seek full repayment of missed payments at the beginning of the year. What I would say to this is that even if a tenant is protected from eviction, they still owe the rent to their landlords, and the rent isn't forgiven. And so I think it's hard to give financial advice to folks, but I think what we always tell tenants is that, you know, you're still going to owe the rent, and the landlord can try to collect it in many different ways. So it's kind of, with that information, it's kind of up to them how they want to pay it back now or later. Anything you wanted to add to that, Maya?
No, I think that's right.
Yeah.
Seems like we are out of questions.
Thanks for taking those last few.
Yeah, of course. Okay.